number 1 of our annual rulemaking agenda. Today is September 23rd, 2021, and the time is 2:01 p.m. This meeting was noticed on our website, and our rulemaking manager, Ms. Spellerberg, sent invitations and relevant documents to everyone on the stakeholder list. This meeting is being recorded, so I would ask each of you to identify yourself when speaking, and I would ask that side conversations be avoided as it will be picked up on the recording. This is a fairly small group, but it's probably still a good idea to mute your microphone when you're not speaking. And I will go around the virtual room and ask you to identify yourself and who you represent. So I'll start with myself. I am Chris Rouse. I am the Division Director at the Auto Industry Division, and I'm also the Executive Secretary to the Motor Vehicle Dealer Board. The next person on the list is Chris Hartman, so I'll let you go ahead, Chris.
I am Chris Hartman. I am the Deputy Director of the Auto Industry Division. Beth?
Next person, the next person is Arlene.
Oh.
Oh, I didn't know I could unmute. Arlene Tappinen, I'm the recorder of the minutes and the Assistant to Director for Auto Industry Division.
Thank you. And next we have Beth.
My name is Beth Spellerberg. I am the Deputy Executive Secretary, Legal Assistant, and also the Rules Administrator for the Auto Industry Division.
Next we have Dave Cardella.
Got unmute. Hi, my name is David Cardella. I am the CEO of the Colorado Independent Automobile Dealers Association.
Thank you. Next we have Frank Agos.
Frank Agos, Supervisory Investigator with the Auto Industry Division.
Next we have Gloria Breeden.
Hi, Gloria Breeden, Compliance Investigator Supervisor for the Background Licensing Team with the Auto Industry Division.
Next we have Howard Lennox.
Yes, thank you. Good afternoon, ladies and gentlemen. I'm Hal Lennox, and I'm here on behalf of General Motors today. We do not have a matter before you, but we will, I believe, have one in an upcoming session. So I have simply joined today to get a sense that I've never had an issue before, MVDB before. And so I'm just attending today to get a sense of the cadence of these meetings and so forth, so that we can be properly prepared when our issue comes up.
Fantastic. Welcome, Mr. Lennox. Next we have Jerry Aboud.
Hi, my name is Jerry Aboud, and I represent Power Sports dealers here in Colorado. Did you hear that?
Yes, we did. Thank you.
Oh, sure did.
Next we have John Opeka.
Hello, my name is John Opeka. I'm the agent in charge for the Auto Industry Division.
And then we have Sarah Killeen.
Hi, Sarah Killeen, Assistant Attorney General from the Colorado Attorney General's Office.
Thank you, everyone, for introducing yourself to the group. This is a stakeholder meeting to review Rule Group 1 of our annual rulemaking agenda. These rules deal with pre-licensing education requirements and pre-licensing education provider requirements. These rules were adopted after the 2007 legislative session and have not been reviewed since then. In 2017, legislation was enacted requiring a triannual review of rules. 24.4.103.3 requires us to conduct a review of the rules to assess the continuing need for and appropriateness and cost effectiveness of rules to determine if they should be continued in their current form, modified, or repealed. It further states that the review must, in particular, take into account whether any of the rules are affected by any federal or state laws enacted or any federal or state rules promulgated within the previous 3 years. There have been no federal or state laws enacted in the past 3 years that affect this group of rules, except for the 2018 recodification of our organic statutes and rules, moving them from Title 12 to Title 44. We've reviewed these rules internally and in the division, and we didn't identify anything that needed to be modified, added, or repealed. This stakeholder meeting is your opportunity to bring forward for discussion any changes or modifications that you as stakeholders would like the Motor Vehicle Dealer Board to consider during the rulemaking process. I will now turn the floor over to Ms. Spellerberg to guide us through the rule review and discussion.
Thank you, Chris. This is the first time I'm being the rule administrator for the Auto Industry Division. My predecessor, Leland Beebe, was the master rule administrator, and I'm more on the level of like the grasshopper rules administrator. And my style is a little bit different than Leland's. Mine is more of a streamlined approach. I'd appreciate this being more of an open dialogue or discussion, and we're here to serve you. So please feel free to comment, make your suggestions, revisions, modifications, because we are here to serve you and your industry. So that being said, there are parallel regulations in our compilation of regulations we're reviewing today. The A section is for the motor vehicles, and the B section is for power sports. So what I'm going to do is I'm going to go through each section and then each item individually and ask for your feedback after each item, because some of these are rather lengthy and we thought it might be more efficient to do it this way. So let's begin. There are 7 rule pairs, and the first rule pair is 1 CCR 205-1, Regulation 4420-118-7D. Item 1. This regulation basically delegates the authority to the Executive Secretary to execute all actions needed to put on the pre-programming or pre-licensing education program. Anyone have any comments or any modifications to this item number 1? Please speak up if you do.
I have a quick question. I just wanted to ask, and I didn't go back, and it's my problem because I forgot to go back and look at Title 44. Is Ms. Rouse referred to in the recodification as only the director, or is she also referred to as the executive secretary? I don't recall off the top of my head. The language of the rule only refers to executive secretary. I just wanted to make sure that parallels the recodification.
The board actually delegates the executive secretary, which in this instance is also our division director, to perform the functions for the board. In this case, the delegation of all the actions having to do with the pre-licensing education program. Does that answer your question, or is
I just wanted to make sure I was clear on why we had both definitions in one person. That was all, and you just explained it to me.
All right, thank you. Do you have any comments about item number 1? No, we'll proceed. Number 2, this actually just gives the executive secretary authority to provide public notice. And she needs to do it immediately after the effective date of the rules. She needs to do it annually by means of publication on our website, the board's website. And it generally, describes basic program of the pre-licensing education program, which needs the approval of the executive secretary. Any comments on item number 2? Okay, item number 3. This regulation just states that the executive secretary shall evaluate each pre-licensing education program for compliance with our statutes and our rules. Item number 4, an approval of a pre-licensing education program is for a period of 1 year from the date of approval. Any comments? Okay, we'll go on to 5. A pre-licensing education program provider can reapply by means of an updated application of the program in subsequent years. Number 6, this authorizes the executive secretary to issue a letter of approval within 30 days of the executive secretary's receipt of either the initial application or the subsequent application of a renewal of an existing approval of a pre-licensing education program. Okay, number 7. The executive secretary shall also issue a letter of denial, and she needs to do that within 30 days within receipt of the initial application or the subsequent application for renewal. Item number 8. Any comments? I thought I heard something. Okay. Item number 8. Any recipient of the letter of denial has a right to appeal the denial to the board by means of request for a hearing. It needs to be done within 60 days after the notice of the denial. Okay, number 9. Any approved pre-licensing education program provider may bring to the board a complaint or concern about the administration of the program application process. But first, the provider must seek to resolve the issue on its own before the request for hearing process begins. The executive secretary shall provide to the board the name of the provider and the term of approval for that provider. 11, the executive secretary shall post on the board's website a list of the names, addresses, contact information as provided to the executive secretary for each approved pre-licensing education program provider. Number 12, an approved pre-licensing education program provider that intends to cease its operations must notify the executive secretary within 180 days. Number 13, an approved pre-licensing education program provider shall maintain a place of business in the state of Colorado. Number 14, an approved pre-licensing education program provider must maintain the set of records and be in place for at least 3 years. And I'm not going to read each specific type of record it needs to keep. You all can read, sure. And number 15, the executive secretary shall have authority as a matter of routine compliance investigation or upon the receipt of a specific complaint to perform investigation of the activities of the pre-licensing education program provider. 16, the executive secretary shall have the authority to obtain copies at no cost to the state of all materials utilized in its pre-licensing education program. And 17, procedures for suspension or revocation of the approval of a pre-licensing education program provider shall be in accordance with sections 24.4.104 and 24.4.105 Colorado Revised Statutes. Does anyone have any feedback, suggestions, modifications, would like to make any comments, have a dialogue? Please speak now.
And as I stated in the opening remarks, we reviewed these internally and we didn't have any suggestions for modifications or repeals. So don't feel like you have to look for something. If it's not broken, we don't need to fix it, is my motto.
Right, this is David Cardella from the Colorado Independent Auto Dealers Association. I would just like to say how great it is working, the way it's set up. and the cooperation among all the parties, both with the licensing process, with the Motor Vehicle Dealer Board. I think they do an outstanding job, especially under the circumstances for the last 2 years that you've had to operate. And it's crazy. I miss seeing everybody except on these Zooms, but I think it works very, very well because the pre-licensing certification is more than just about 60 questions that they have to answer, and it's really about the structuring of how to properly follow the laws and regulations. And I think with the providers, I think it works very well, and I would hate to see any changes made.
Well, thank you, Mr. Cardella, for your comments. Much appreciated. Okay, now section B is for the power sport vehicles, and it's the parallel regulation to the one we just reviewed. Do you feel the need for us to go through each item that is parallel to the ones we just, discussed, or or do you think we can just go to rule pair 2?
From my perspective, I just read them parallel. I didn't see anything in the power sports world that needed to be adjusted any differently from the motor vehicle stuff. So I would be good with that, just going forward with the next rule.
Okay, Mr. Cardella?
Yes, no, I think it works very well. It's easy to cover them both, and I don't see anything that needs to be changed.
All right, thank you for your comments. We'll just proceed to rule group 2, rule pair 2. So this, for motor vehicles, it is 1 CCR 205-1, regulation 4420-118, 7F1. This requires that the pre-licensing education program shall include its content, federal and state, Colorado state laws, and federal and Colorado state regulations governing motor vehicles dealers. Any comments? Okay. And it's the same thing for the power sport in section B. Hi, Jerry. Yes.
I'm going to tell you, there is one thing that isn't in there that I think ought to be included in the various titles that are taught and or in educating the folks. And that in the power sports world, there's a parallel to the titling and registration. The registration or the titling portion of it is already covered. You've already got that. But what isn't covered is the dealer's requirement to provide the registration and have the purchaser fill out the forms for registration for the Division of Parks and Wildlife for off-highway vehicles and for snowmobiles. And that is a requirement of 33. I'll tell you, it's Title 33. If you wish to be more specific, snowmobiles are Article 14. Off-highway vehicles are Article 14.5. And I don't believe many people would know that unless they were given some sort of introduction to understand that there's a registration in addition to the titling part, because it's really nowhere mentioned in the motor vehicle titling statute where snowmobiles and off-highway vehicles are discussed.
So, Mr. Aboud, would it be your recommendation that we put where it says, the curriculum shall contain without limitation titles 4, 5, 6, blah, 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 that we add Title 33 to that?
I was just leaving it open to you. That would be the easiest way, because we're only talking about 2 articles, and they're brief. So yes, if that's the way you'd like to refer to them, as you have with others by title, that would be fine.
We can do that.
Does that make sense to all of you when I ask for that? That we're just basically paralleling the registration of motor vehicles. That's all. So I hope you find that okay.
That is fine. This is for you, the stakeholder. So if that's what you would like for us to modify, then we will do that.
Well, thank you very much. I'm used to having more fun with arguing, but this kind.
I can argue.
Usually trying to somewhere to create a dust up, so.
Come on, Jerry. This is going nice, this is, but Jerry, can you send that? Can you send me that language so we can include that, make sure we do it the right way on what you were saying? Because I think that is important with the wildlife registry, you know, at the parks.
Yeah, it's generated about $130 million for
Right.
backcountry in Colorado, so I think we'd like to have summer and winter
Right,
recreation in the mountains available. And most of those trails, cross-country skiers use, so the reality of it is it's nice for a dealer or a salesman to know right up front that that's a part of their job.
All
We
right.
don't have CDOT. We don't have CDOT breathing down our neck.
Okay, thank you. We'll move on to rule pair 3. And for motor vehicles, it's 1 CCR 205-1, regulation 442118, 7F2. So this basically states that an application from a prospective pre-licensing education program provider or a renewal application must contain the following items. Identifying information, which is, I don't need to go through it, but it's basically name, legal name, address, etc. That's A of 1. B of 1 is the contact information to include the name and title of any individual who has authority to speak on behalf of the applicant. C, the pre-licensing education program proposal for delivery of the required education, which includes other to complete the 8 hours instruction, what the curriculum is going to be, what classroom materials they'll be using, any ancillary items that will be used in the course, etc. Any comments on that? Nope? Okay, thank you. Item number 2, the provider of a pre-licensing education program must have a minimum of 3 years experience in the regulation and compliance, and enforcement of state and federal laws governing motor vehicle dealers and motor vehicle sales, or have 3 years experience as an instructor working for an approved pre-licensing education program provider. And number 3, executive secretary shall require additional information from any applicant in the event that the application is deficient or there's, more necessary information is needed in order to reach a decision on the application. All right. Oh, someone, David, go ahead.
so Mike, our attorney I don't know if this is where I should bring this up. He said to teach the pre-license class, is this what we're covering right now? The instructor? He says it should have to be a licensed attorney with at least 3 years experience in representing car dealers and providing instruction on state compliance related to dealerships, or a current employee of a pre-licensed provider who has 3 years experience in teaching compliance classes related to motor vehicle dealers and state laws and regulation related to motor vehicle dealers. And I think why he wants it in there is because there's so much more, like I said earlier, than just teaching the class. It's how to pass a test. It's about teaching how to operate properly and the ups and downs and pitfalls you can encounter. But hope
I hear what you're saying, and I don't believe any of the regulations really specify on the instructor's and what their licensure or credentials should be. This is more vaguely speaking on the program itself, and not the instructor.
I
But
think the
if you
instructor's got to have 3 years teaching, right, Chris, or,
well,
right?
that was just a provider, like the CIAD or like the provider must have experience. It doesn't really specify like the instructor or instructors. But if you want us to add that, we would be more than happy to.
But I think what we're concerned about is we don't want someone deciding that they want to teach this and not have the proper education and requirement or experience in the laws, rules, and regulations that govern the industry. And now we're putting people in business violating the law because they were never taught the right way. But if you think it's covered, and if you think it's covered the way it's written, then I'm fine with that.
So if you look at item C, and then it talks about number 3 in parens after C, the full legal names and dates of birth of all instructors, teachers, and curriculum preparers, and their respective educational credentials. Faculty additions and changes may later be made, subject to approval by the executive secretary.
Okay.
Right there, is that where you would like more specific?
Well, if they're subject to the executive secretary, I think the executive secretary is already aware that they have to have those kind of credentials. So I don't think there would be a need to add the change. As long as we're clear that that's what it's covered. I mean, I think the executive secretary understands who needs to be teaching it. So I would be fine with leaving it then.
Okay. Everyone else okay with that? All right, thank you. I forgot where I was.
Sorry, my fault.
That's
I
okay.
have to do that to people. I don't mean to say that at all.
All right. Oh, we talked about identifying. Okay, I think we're on 2, talking about the application or a renewal application for the pre-licensing education program provider. They need to have the identifying information, and then they need contact information on who will be speaking on behalf of themselves. And then C is the proposal for delivery of all the required education. And, this is where it talks about the things that, David just brought up, and, you can go through that. If there are any other modifications you want, or not any other, but if there are any modifications you want to any of these 7 items in section C, please feel free to speak up. Pretty wordy.
If I mean, I think what David was saying is the McKinnon wanted the 3 years experience as an attorney added to number 2, along with the 3 years as an instructor, or 3 years of this, or as an attorney. That's how I was hearing him.
Well, I think we're just kind of concerned that we don't want people without the experience or the knowledge coming in and trying to compete as a pre-licensed provider, and not really concerned about the industry the way our associations are concerned about the industry. We'd hate to have previous employee or somebody decide, hey, now I want to become a pre-licensed provider, and I think they either need to be an attorney with that kind of experience or working for a pre-licensed provider in order to do the class.
Well, we don't discriminate. We'll let an attorney apply to become a pre-licensing education program provider, but they would be held to the scrutiny of the executive secretary. We don't allow just anyone to do it.
Right, okay. And I think that's what his concern was, so. And also ours, I mean, we don't want in-up dealers getting out on the sales force. We try to limit that as much as possible, right, Gloria?
We would do a thorough background check as well, if they were like a former dealer.
Right.
Okay. This is where I was when I, on section 2, it says that the provider of the pre-licensing education program must have a minimum of 3 years experience in regulation and enforcement of state and federal laws governing motor vehicle dealers and or power sports vehicle dealers, or have 3 years experience as an instructor working for an approved pre-licensing education program provider. Would you like any modifications to this? Do you want more than 3 years, or is 3 years sufficient?
I think 3 years is sufficient.
Okay. And item number 3, executive secretary shall require additional information from any applicant in the event that the application is deficient with regard to any of the noted materials, or in the event that more information is needed to reach a decision on the application. All right. We'll proceed to rule pair 4. 1 CCR 205-1, Regulation 4420-118, 7F3, and this is for motor vehicles. A pre-licensing education program provider must maintain an educational site or sites appropriate to classroom instruction. Okay. Number 2, a pre-licensing education program provider must ensure the integrity of its educational materials and the instructional records of its participants, each being subject to inspection by the executive secretary. Okay. 3, the executive secretary will evaluate each prospective pre-licensing education program provider and each prior approved pre-licensing education program provider reapplying for program approval. And that was the motor vehicle regulations, and the power sports is parallel to that. Okay, we'll go on to rule pair 5. This is 1 CCR 205-1. Regulation 4420-118, 7F4. Item number 1. The methods of instruction may vary according to the approved pre-licensing education program. It may include traditional and non-traditional classroom instruction geared to adult learners, with testing validation, CD or DVD instruction, with provisions for testing validation. Yes, Jerry.
On rule pair 5, A11 and B11, since it uses the language may, in this day and age, website-based education is extremely common, and I was just wondering why under 1, the traditional and non-traditional classroom instruction geared to adults, it talks about CD or DVD instruction. Is there any reason we don't have website in there? Website-based education?
There's no reason whatsoever. We can add it, and that was my question too, Jerry.
Oh, okay.
But I wasn't going to ask my question because this is your deal, not mine. So
I'll ask mine. It says may, and there's certainly no prohibition that appears in that. However, someone may want to do it, and all they will do is waste time by calling you. They're going to have to show you the curriculum anyway, so perhaps you should signal to them it's okay to go ahead and build it if you choose to in a website-based program. and then they can come at you with the finished product rather than bothering you to see if they can do it. I mean, you might as well mention it in there since those are all optional. I'm just giving an rationale for why I think you should mention web-based education.
Okay. Let me repeat back what I wrote down and see if it's correct, okay? Okay, so after 2, we'd still include CD or DVD. Are there CDs and DVDs available for this instruction? Are those still available?
I mean, this is an in-person class. Are you suggesting that the class be allowed to be taught over the internet or through a DVD? I mean, because we teach it only in class, the instruction, so we can make sure that the right person doing the instruction is the one in front of you.
What did you do during COVID?
We taught classes. We just limited the size and spaced them out in our classroom.
Would you ever feel
made
the
them wear
need?
the mask, because we have to witness that these are the actual people attending the class, because that's what we're signing the certificate for, that they're the actual person attending the class and answering the quiz questions, because there's quizzes also throughout to cover the modules as we're teaching the modules that they have to answer. We want to make sure those are the people taking those quizzes, not somebody else in the room giving them the answers. And then that is the person who we're certifying as the dealer or the salesperson. I mean, because then they have to take the test, and that test also has to be certified that you watched them and they didn't have somebody else there giving them answers, or they had, the answers to the questions. So
All I'm saying is if someone wanted to make an 8-hour, let's say someone wanted to make a recording of their entire classroom so that a person could go back and actually take the whole thing on a website or a CD or DVD where it's recorded. It doesn't substitute for the training of in-person in a classroom setting, but it would allow a person to go back and review the whole course if they chose to, as it's taught, if they wanted to go back and review it. That's all I'm talking.
yeah, but Jerry, the problem I see with that is then you've got that information getting out to others who haven't taken the course.
Well,
There's no way,
it's in the statute.
well, but there's,
The person needs to know is in the law. So what are you disclosing that's not in the law?
that's what they're coming into the class and paying the instructor to do, to teach them the laws and the rules and regulation. Under that, they would be able to have all that information, which also helps them, people send their salespeople in now and pay to take the class, which we charge less money for, so they can have that information. If you're able to record that information, there's no need for that.
Well, then, I guess I don't know about why we always had CD or DVD instruction with provisions for testing validation in there all this time. If somehow, I guess the way I would put it, the way you're putting it is, the classroom is proprietary. I assume if someone copyrighted their curriculum, the question is, could they? My response would be, I'm not so sure they could, because everything contained in there, and I hope our AG is listening, everything contained in there is public record. There is nothing. They can add information to it. But generally, questions and answers going back and forth isn't proprietary because it's been transmitted once. So what I'm trying to say is, if you wanted to go back after you took the course and go through the course again, why, since you paid for it once, couldn't you sit down and listen to the course presentation either by website or CVD or DVD? Otherwise, I don't understand why CD or DVD is in there. That's what I'm saying. I'm not saying you substitute it. I'm saying these are supplementals. This is supplemental. But if the state says you must be in the classroom and take the training, then I guess I don't know what the problem is allowing someone access to that.
And just for a point
The
of
provider doesn't
clarification,
have to do it. The provider does, excuse me, the provider is under no obligation to provide anything beyond the classroom. Let's make that clear. That is an option up to the provider. So I'm not sure what the problem is. Someone will have to explain to me both legally and morally and practically what is the problem with that.
and just for a point of clarification, the actual statute, 442118(7), is talking about pre-licensing education for those seeking to be a dealer. It's not about salespeople. So this is the 8-hour pre-licensing education for dealers, for used motor vehicle and used power sports
And
dealers.
that's in person, Chris? That's in person, correct?
It does not say anything about it being in person.
Oh, that's interesting. So they could, if they could have it by webinar. They chose. Is that what you, I mean, I wouldn't want to recommend anything as a substitute for what the division wants, because it says classroom, 8-hour classroom instruction. It's clear on that. I don't think you can argue that 8-hour classroom instruction, in this day and age, however, I don't know what the interpretation of that is because of COVID. You know, it sort of muddies the waters.
Then maybe we need to add into that language in-person instruction in the classroom.
That's right. Maybe that needs a little more clarification. Maybe staff wants to take a look at that, Dave, and see exactly if there is any specifics. It doesn't say it has to be in person in the statute. I won't go into whether, from a regulatory standpoint, the board could require that be done in class, in person, what you're saying here. We're talking about classroom instruction. You're talking about in person. I just want to make sure I'm on the same page with you, Dave. You're talking about in-person classroom instruction, right?
That's correct. I think it is very important that they are in-person classroom instruction so they can have the back and forth exchange with the instructor that you can't get off the webinar. I mean, if somebody was just to record their 8-hour session and make it available, you're not having that back and forth exchange of questions and answers that instructor gives on that hands-on instruction. And I always thought that that was in the statute, that it was mandatory in the classroom.
I see your point, but to me, when it says, it's interesting, it says it may include within the 8-hour classroom instruction. That's not mandatory, and as Chris says, it's not specified in the statute. So I won't go any further with my comments simply because I'm basing this on the fact that regardless of how or what they require, it doesn't say in there anything about, now Chris clarified that for me, the statute doesn't say anything about how that education will be provided specifically. So I would just simply step away and say, if that's an issue in and of itself, as to whether it must be in-person instruction, then that's a different issue, Dave. You see what I'm saying? Then we need to have the folks that require the education comment on that. So that's what I'm getting at.
And I will say, and I hate to read to people, but I'm going to read to people what the statute says. It's talking about a person applying for a used motor vehicle dealer license, a wholesale dealer license, the whole laundry list of licenses, shall file with the board a certificate that the applicant has met the educational requirements for licensure under this subsection. Doesn't say anything about it being in person in a classroom. So that's where we need a regulation to say what is going to be acceptable. Because I don't use CIADA because they're the main education providers.
Right.
If you guys are comfortable issuing a certificate to somebody who's watched a DVD or CD, that's up to you. I wouldn't love it, but it's up to you because you're certifying that they've met these requirements.
I have a comment to piggyback on Chris. You don't have to instruct them by DVD or CD. We can eliminate that language, and it's up to you whether or not you want to do it in person or online. You can hold instruction, a classroom instruction, virtually. It's live. You would have the interaction back and forth between the participants and the instructor, and it could be held for 8 hours. You would be able to verify people's, identity by requiring some kind of, ID check, outside of a virtual meeting. But I mean, there are a lot of online, virtual, real-time classroom instructions available. So my question is, would you want to limit yourselves to only in-person, especially in light of the fact that, we have all these new strains of, COVID?
Yes, I would want to limit us to in-person instruction. Again, you're not talking about a one-on-one teaching situation. You're talking about a classroom of 15, 20 people at a time, and doing that on a Zoom does not work well. Where you have some in class, you have some on the Zoom. I just don't think it's efficient, and I think the extra requirement on the in-person class is important. I mean, maybe we can take a deeper look at it, but I guess I wasn't prepared for that question to come up, because I have always been under the understanding that it has to be an in-class presentation. People have to be in class, because we talked about it during COVID, and there is no even we had these conversations. I think it's got to be in class, in the classroom. If you're going to be a dealer, the 8-hour class, with 20 other people or 15 other people, it just doesn't work well when you got 3 on Zoom and 10 in front of you. I don't believe. I've been on multiple Zoom meetings. They just don't flow.
Okay, well, we respect your opinion. Jerry, are you in line with what David has shared? Are you on mute? I can't hear you.
Jerry, you're not on mute. Jerry, you're on mute.
There we go. Sorry, apologize. I started to say that I didn't come here with the opinion of whether it had to be in classroom or not. I just sort of took it as a little bit looser, and that's what Chris sort of, and I think Dave, I wasn't 100% sure, like you weren't either, that what the statute read, and clearly the statute doesn't identify whether it has to be in person or not. I hear folks from the dealer board saying that could be made a requirement that it's in person. So I don't have a position on that right now. Long ago and far away, when you had to study for the bar exam, you could go in and you had to do it in person. Now you can go online and study for the bar. I assure you the bar is more difficult than the dealer licensing test. So my only concern is, from your perspective, are you making it any more difficult to provide your product by making it classroom only? In other words, somebody's going to have to get certification. If the state would accept a webinar certification, if they pass the exams afterwards, if you charge and the webinar is proprietary, it says certificate. I guess a lot of it depends upon who issues the certificate. You see what I'm saying? Is the CIA DA folks, once you've taken your course, do you issue a certificate of completion of the course?
Yes. And once they pass the test.
Right,
if
no,
they're
no, that's what I'm
required to
saying.
pass the test. And
Right. But if a person didn't want to take the test, or didn't want to take your webinar, or excuse me, your classroom, and went in and passed the test, does that satisfy the requirement? Because what I'm getting at is, I have no position about that won't satisfy the requirement, right?
right,
So, as I understand it, they have to take the course in some fashion, pass the test, get certification, and that's the only thing that satisfies the dealer licensing board. I just want to make sure that's correct, what I'm saying. Is that correct or incorrect? Ladies, correct?
That's correct.
That is correct.
Okay, so all I'm saying is, if that's required, why would you ever issue, if someone got online, somehow had access to your webinar, did it, took the test, you still haven't issued a certificate because they haven't signed up with you. I guess I'm missing I may be missing the process here, but what I guess I'm trying to say is, however I studied for the bar, I got to take the bar exam. But in your case, I mean, I don't need to take the course. State certifies me as a lawyer or not. I'm just trying to find some kind of parallel. But in this case, the state's saying you have to complete this course in addition to passing the test, correct? You have to have taken the educational hours formally before, then you take the test, but you have to walk in with a certificate from one of these providers. Is that the process, right? So how can someone go outside of that with a webinar, even if they had access to it? Because why would you ever issue a certificate of completion? That's what I guess I'm not understanding.
well, because you don't know if they're, Jerry, you don't know if they're actually there for the whole course, learning the whole, I mean.
Well, what I'm saying is if they passed, let's say they came for half of the test. If your sense is, or your feeling is, that passing the test is just not adequate, even if they sign up with you, even if they only didn't show up all the time, they passed the test, is it your concern that they're not getting the full benefit of the course if they take it online? Because what I'm trying to figure out is, I'm trying to figure out why, if you have to certify it through CIADA, if you have to certify that they've completed the necessary training in some fashion, and then they pass the test, is your concern that someone with an IQ of 180, if they don't go through your 8 hours, and they could probably teach your instructor, even if that person was a lawyer, that they shouldn't get a certificate? You see what I'm saying? I'm trying to figure out what it is that has you glued to their in-classroom when you have control over the issue of the certification.
Because if they're doing it by web, you don't know if they're actually there for the full 8 hours, listening to the full 8 hours instruction, which is what is required to issue the certificate. And now we're issuing a certificate without that knowledge. We know the people that are in our classroom when they come here for the 8 hours. They're here for all 8 hours. They're the ones that were issuing the class. So I don't.
Well, I don't have a problem if you feel like that. I'm not objecting to it. I'm just trying to understand. But I'm not objecting. So I'm just truly trying to understand the classroom.
Well, and this is the way it's been done. And as Chris said at the beginning of this meeting, if it's not broken, don't look for a fix. And it's not broken. It's worked well. There's about 1,360 independent dealers, and over 1,100 of them belong to our association because of the training we give them here. And I think that is because they see the importance of that training in the classroom. I wouldn't want to change anything, so.
I'm not disagreeing. All I'm trying to reconcile is then you need to put in there that it's required to have the classroom. Because that isn't what it says now, Dave. It doesn't say the classroom is required.
It does state in Regulation 4420-118-7F3 that they are required, the pre-licensing program provider must maintain an educational site or sites appropriate to classroom instruction. That could be in person or online.
That's why I'm confused. When he says, Dave, when you say it's been this way forever, it has evidently, but it hasn't been a requirement that they be in the classroom, at least from a regulatory standpoint. So that may be something you want to address.
But what I hear David saying is that based upon his experience with Zoom, Google, WebEx meetings, that when they're hybrid, where some people are in person or some people are on the meeting virtually, it doesn't work as well as when they're all in person. So David, if you'd like us to specify in-person classroom instruction, we can add that for you.
Yeah, I don't, I mean, I have.
This is for you.
Yeah, I think, correct me if I'm wrong, I think that's the way it's always been done. I think it works well. I think we train people well, and if that language needs to be added, then I think that it needs to be added in there.
Okay. Do you
I
want
would ask the AG to interject too on that. So Sarah, Ms. Colleen?
Yes.
So if we were to put in that this has to be done in person in the classroom for the education, is that barring people from being able to access it if they wanted to do something different, a different provider? I'm not saying CIADA, but if a different provider came in, is that setting a bar that this is going to cause a challenge to this rule?
Well, the statute says the board sets the methods of instruction. So if a rule is set that the only method of instruction available is in person, then any subsequent potential applicant or provider would have to comply with those rules. So yes, it would be limiting future providers in terms of how they would provide instruction. If you specifically identify that the method of instruction is to be only in person.
What I'm seeking a little bit of clarification on is, will this cause a challenge to the rule during the rulemaking process by all the various reviewers if we put something in that said it had to be in person? And I'm not advocating for it to be 100% in person. I'm just going forward with what Mr. Cardella is kind of advocating for here, is that it be in person.
Oh no, she's out. Technical difficulties. Oh, there she is.
Well, can you hear me? I think my
Yes.
internet is being temperamental, so I turned my video off. I would have to look into that. Honestly, I don't know at this point if that would pose a challenge to the review at a later date. I think it's something I have to look into, and it may be.
I mean, I kind of feel like the way that it's written right now gives a little bit more flexibility, and we haven't run into somebody who said, I want to do online webinar only kind of events. So this challenge hasn't come up, or this problem hasn't come up. But should we go down the path of saying in person only, or should we leave it the way it is now, which is a little more flexible, and nobody's asked for that flexibility as an accommodation during the pandemic even, let alone full-time, that's how they're going to present their program?
If that's a question for the AG's office, I think that's up to you if you want to go down that road, and if the stakeholders want to limit the rule to just in person, that would then have to be reviewed by the AG's office, and it would trigger additional review down the road. So I can't give an opinion at this point whether or not a rule change limiting it to in person, how that's going to play out. But I think it's up to the stakeholders. If you want to go down that road, then we can obviously review that.
And from the perspective of what we've just gone through with the pandemic, I don't know that I want to limit it, you know, to putting something in there that says it can only be in person. I don't know if I'm comfortable with that. So if we could have a little bit more discussion about that, that would be great. I think it's kind of counterintuitive coming hopefully out of this pandemic to say we only allow in-person training.
My concern about allowing online classrooms is, 7D13 says they have to maintain a Colorado address, basically. And they're online, because we get calls from people out of state who want to do this online because they can do it from their state. And if you're letting them do it from out of state, how do we know where they're at?
But I don't think we're talking about letting them do it out of state, because we're leaving in place the requirement that they have a classroom and a requirement that they have a physical location in Colorado.
But if I'm doing a Colorado class, how would you know that I'm there?
I'm sorry, I talked over you.
How would you know that they were in Colorado?
I wouldn't.
I mean, I can go down to CIADA and look in the door and say, yep, they're here.
Right,
We just have so many people who look for ways, Chris and the tiny homes guy, so many ways that just look for ways around what we've got. And I think if you open it up, you're going to have people saying, okay, I'm going to give you a Colorado address, but I'm going to be maintaining this from my home in Wyoming and offering this class.
Well, my thoughts on that are, the executive secretary has authority to review all applications and review, ask for additional information. And if there's something sketchy on there, she can send an investigator to go see if they do have physical presence here. I mean, she has authority to review all that information and vet out that provider.
If I can add something, having gone through a traditional university and gotten a degree that way, I personally do not like the online education, and I've watched my wife do it, and I don't think that it's as valuable in the long run. But having said that, I think it would be counterintuitive to limit the classroom to in-person only, just as Chris said, in lieu of the pandemic, people having different comfort levels in whether or not they want to sit in a classroom with other people. But also just kind of, sign of the times. I mean, I think probably more people get education online than they do in classroom now. And it just, it seems counterintuitive to me.
And who can predict the future? Who's to say that, we'll be able to even work together again, full time, or, so who's to say that CIADA will be able to open its doors to instructees for their program? I like having options. And the language that is currently in there provides the providers with options.
So I think we need to come to somewhat of a consensus here so that we have what we're going to bring to the Motor Vehicle Dealer Board. Are we going to not change what it currently says? Or are we going to add that this must be in-person training?
You know, I'm torn because I see what you're talking about. We have had people ask about being able to do it by Zoom. And our response has been, no, it's got to be in class, and they if they want to be a dealer, they make the effort to come and do it in class. And because of, you know, like Gloria pointed out, I mean, there are just, people find ways around things if you give them that option of opening them up. I know everybody, the world's gone upside down because of the pandemic, and everybody thinks that there is a lot of things that are being changed because of the pandemic that has resulted in some difficulties for our industry. And our dealers are still being held responsible for it. I don't think you change things because of what should be a temporary situation. If the pandemic goes away, we're all going to be dead anyhow, so what the hell does it matter? We're not going to need cars, and then we won't need car vehicles. But this has been done this way for a long time. It works well. I think, I guess we could offer a Zoom, but again, I just don't like the ability of somebody to not, you don't know if they're there taking the 8-hour course. And if they go online and they can say, well, I watched the 8-hour course online, but you don't know if they actually did. And then they want you to issue them a certificate because they were able to pass a test. You know, who gave them the test? Who oversaw them giving the test? We're here, we're controlling that. We watch them take the test when they're done with the class. If they don't pass, they have to come back and take the test in our classroom. So that's, we're looking for a fix that I don't think needs to be fixed. The system works well. I always thought it had to be in person. I guess, Chris, it would be up to you if something popped up, and so we could leave the language at saying that because of a pandemic, you can teach it by Zoom. But I don't like it. You're signing and verifying something that you don't know is actually true. And you know, it's not black and white. You know, you've got some gray area in right now. And you're putting your license at risk to teach the class. And I'd hate to jeopardize it, and I'd hate to jeopardize the education we provide our dealers.
Well, and Mr. Cardella, if we left the language the way it is right now, that's not forcing you to do it in a classroom. That's up to you. That's a business decision as you're the education provider. If you decide that you want to have them in the classroom 100%, that's your business call. And I think you guys are the only program providers, you and Connie Hatch, and she's associated with you. So I think, you know, if that's the business decision that you make, that you want to be there because you're putting your name on that certificate, swearing and attesting that they've had 8 hours of education and it was indeed this individual, that's your comfort level. And I think the way that it's currently written allows you to do that.
Okay. Yeah, I would hate to see somebody now apply to be a provider and teach it all by, teach it by Zoom, and it just opens up a lot of loopholes, I think. You know, and I look for not creating problems. And I think that would create a problem, but I guess that would be entirely up to the board to decide whether or not to issue that provider a license to even teach it. So I guess it would fall on you and your due diligence and your responsibility. So, and I know you would do your due diligence, so I guess I'm okay with that. So I trust your opinions.
Thank you, Mr. Cardella. What about the item number 2 in that paragraph, CD or DVD instruction? Is that being done now?
No, I mean, we don't provide any material. There is a manual that we use, to help them review the rules and regulations, that we taught them throughout the class, during the class. We don't allow that to leave our possession. I mean, that does not leave our building or our classroom. So, and they can't, they can't take pictures of any of the material. They can't take pictures of the test. And a number of years ago, I was a car salesman. I mean, that's all I've done my whole life is sold cars. When I came to the state in 1987, I was told, well, you got to get a license. And I came from Illinois and Florida where you didn't need a license. And I said, license? Oh, yeah, you got to pass a test. A test, 50 questions. But don't worry, we have all the answers. Okay, I mean, that's what happened prior, if I'm not mistaken, and that's why the state spent almost $3 million developing this set of questions and the way the program is issued. Because they didn't want that, that information getting out to the public to where people could avoid having to take these tests, having to take the classes to learn about the laws and what governs this. Is that correct, Chris? Is that why they spent the money for this program with the questions?
Well, this is a very long-winded answer to your question, Mr. Cardella. Sorry, I apologize in advance. So what happened is in 2007, when they were doing the sunset review, we had made a recommendation, the division, that they get rid of the mastery exam because it was, a paper exam and it was getting cheated on and people were handing out the answer key along with the test and all sorts of good stuff. And I was not involved at the time. I was not the director or the deputy director. But then there was also the pre-licensing education program where they felt that people that were going to become used motor vehicle dealers needed to have instruction, that this was a very complex thing that involved a lot of federal law, a lot of state law, all of that good stuff. And so they decided that they were going to have the pre-licensing education and that they were going to continue to have the mastery exam. And they decided that they wanted it to be a psychometrically valid test. And at which point in time, I was tasked with making a psychometrically valid test. So I contacted CSU and worked with the professors over there to develop those 61 questions. And then we decided we wanted to have a better, more modern delivery method. So we weren't mandated by the legislature to do that online. We did that because it was more modern than a paper test that could be passed around. Plus the questions could be randomized, which made it more secure and made it more psychometrically reliable and valid testing materials. So long-winded question, answer to a simple question is, yeah, that's kind of what happened.
Okay, thank you. I love the industry. I want to protect our industry. I want to keep bad players out of our industry. And I think this helps keep bad players out of the industry. And I'll give you an example of Florida, where their bond to become a dealer is $25,000. And that $25,000 bond costs over $2,000 for the dealer to get, whereas we require a $50,000 bond and it costs $450. And that's because our dealers are better trained in the aspect of the laws and regulations, and it's a vicious circle, but it kind of all works together. And I'd hate to see us go down that way, and it could easily happen if you open stuff up.
And I'm all for having the training. Believe me, I think it's a wonderful thing, and I think it's also great for consumer protection because a well-informed dealer is going to do things the correct way rather than the incorrect way. So I think education is paramount. It's just, are we going to make it mandated to be in person, or are we going to leave it a business decision of the pre-licensing education provider and not change the regulation? That's what we're basically down to, in my opinion.
I think you leave it. I think it would be easier leaving it the way it is, a judgment. And if it did get out of hand, I guess we could always go back and review that if that's what happened.
Precisely. If we do encounter problems in the future, we can always revisit the rule through rulemaking.
Jerry, do you concur? You're muted. I hope that's a yes. Jerry, you're muted.
I hope that, I don't know that since we just discovered that there is no requirement in person, it appears that it hasn't affected, Dave, in that respect, that people seem to come in and they're willing to take the 8 hours with a classroom exam. And I'm certainly not going to run around and tell people otherwise, so hopefully things don't change. If we don't change it, if we just leave it alone. So that may fulfill its purpose, and I do agree if there's a problem, they will let us know, we'll let you know, and perhaps at that time we can review it again.
Thank you for your comments. Let's move on to Rule Pair 6. Section A is 1 CCR 205-1, Regulation 4420-118 7G. This gets to the point about issuing a certificate of completion once the person successfully completes the curriculum in the pre-licensing education program. It states it must be issued 10 days upon successful completion. Is that okay? And the power sports regulation, which is parallel to that, is exactly the same. So now we'll go to Rule Pair 7. This is our last pair. And the motor vehicle regulation is A 1 CCR 205-1, Regulation 4420-118 7H. And this just authorizes or actually expects the pre-licensing education program provider to issue to the executive secretary a copy of the participants' successful completion of the program within 10 days. Everyone's nodding yes. All right. Well, thank you everyone for your time and energy and feedback and concerns. And if I can just reiterate, we're only making one change, and that's in the power sports regulation of Rule Pair 2. And we're going to add Title 33 to the education curriculum titles in that paragraph. Is everyone in agreement with that? That's the only change? Okay. What I would like to do is, Jerry, you suggested that, didn't you?
Yes.
If you could please provide me by email the language that you were using about the titling registration for Division of Parks and Wildlife, like why you think it's necessary that Title 33 be implemented or put into that regulation. So when we bring it in front of the Motor Vehicle Dealer Board, we can explain why. Would you be willing to do that?
Oh, yeah.
Okay, I really appreciate that. Thank you so much.
What's your time frame? Pardon?
Huh?
What is your time frame for that? I mean, do you need me to get to you by Monday, or when do you need it?
As soon as possible.
Okay, well, that's what I need to know. It's not much.
Yeah.
Let me put it this way, Dave's not gonna be up nights trying to change his curriculum, adding this to it. How's that? It's gonna be 2 paragraphs. I'll give you the article, I'll give you the section. How's that?
That would be wonderful. Thank you so much. I appreciate it.
All right.
Does Chris, would you like to take her out?
Yes, Yes, thank you very much. I appreciate everybody's time and commitment to these draft rules. I know that you all have businesses to run and things to do, so I greatly, greatly appreciate you working with the division so that we can get everybody's viewpoint so that we bring a good product to the Motor Vehicle Dealer Board in order for them to promulgate rules or changes to rules. So thank you very much. And we will be noticing our next set of rules probably in the next couple of weeks. So that will be tackling ad rule number 3. So I know Mr. Lennox is anxiously awaiting that, so I thought I'd throw that in at the end just for Mr. Lennox's benefit.
Thank you very kindly. Thank you.
And that concludes this rulemaking stakeholder meeting. The time is 3:21 p.m. And again, I thank everyone for their participation.
Thank you very much, everyone. Have a great day.
Take care. Bye-bye.
Thank you for putting this on. Very good. Thank you very much. You guys do a great job.
Our pleasure.
Let's copy them like we did.